Funds may be generated from the domestic sources, from the internal resources, as well as it can be borrowed as well. So post pre-independence scenario, the borrowing was from the private sector, and there was a concept of banks as well. They were in existence at that time as well. but that was not so structured, organized, and scattered all over the places. So there was an unorganized sector, the we can call as Mahajans, and then there was a structured sort of banks. So, how these banks operate, how it can be regulated, all these things are considered in the unit number 7. Then there are subsequent units also which are specifically dealing with the financial aspect. So, we all understand, yes, finance is required, and finance may be sourced from, as I mentioned, from the domestic sources, like partners are venturing into their own funds, into they're boosting their own funds into the system, but they may have a limit, and beyond that limit they need to borrow, and this borrowing may be on some sort of terms and conditions. Any borrowing from a financer. So in borrowing, there are two components. One is a financer, and another one is a borrower. Borrower is one who is getting the money. In the entire cycle of this financing, taking money, investing it in the some enterprise activity, generating some revenues or profits, and returning back the amount decided upon along with interest, or the principal amount plus interest to the financer is a cycle. The financer or banker themselves may not have the a sum total of all the accumulated money. They themselves require this money from the other sources. Means bank acts as a mediator. At times, it acts as a mediator between the investors. Investors are those that invest money, their money into the bank, and the borrowers. So bank is basically acting as a mediator. Bank should ensure safeguard of the money that is invested in that bank by the investors, as well as should ensure it gets back the amount it has lended to the borrower. So that is, and in the meantime, this cycle it should earn profit as well for its own sustainable survival. At the same time, the borrower, because investor is someone who is having some amount to invest, so he must ensure that his fund is also stabilized or stable, or he must have some confidence in the bank. So his stake is altogether important as well. But at the same time, if I'm talking about the borrower, so borrower need to invest the borrowed money in a manner, in a judicious and intelligent manner, that it gives back some reasonable profit, and that profit is so much that it is able to return back the borrowed money as well as the interest as agreed upon. So at times, what happen is there is some error of judgment on the part of bank, maybe on the part of borrower, or there may be some fraudulent intention as well on the part of borrower. That money is lost, and the money lost is definitely the money lost of an investor. But for investor, banker is a channel. So to safeguard the rights, banks may at times take some harsh decision of that maybe end up in the sort of exploitation of the borrower. So to address all those things, to understand how these things can be regulated, what can be the minimum conditions in which bank can receive funds, or what can be the minimum condition or maximum condition or type of interest, or uh, loan mechanism, type of loans, type of interest, and recovery mechanisms. So these things came into force through the mechanism of evolution of a banking regulation. And because we understand that finance or banking, if we say so in a very comprehensive manner, is very important phenomena. So previously, majority of bank was in the private sector. So post uh, the scenario when the banks were taken over by the government. So the there was a essential need to regulate their function, to channelize their finance into the diverse sector, including the rural sector. Previously, the banking sector was more or less focused towards the urban sector only, or the industrial sector only. So rural sector was altogether untouched sort of thing, but funds or finance was altogether required for that sector also. So there was a concept of priority sector lending to address the lending to the sectors which are altogether ignored, but they require financing, and financing or funding in that sector will definitely result into the increment in the economic growth of the nation also. So address all those issues over the period of time. Banking regulation need to be evolved, and they kept on evolving at the domestic level as well, and taking the cues from the domestic scenario as well as taking cues from the international standards in the form of Basel 1, 2, and likewise. There has been a reasonable mechanism of uh, stepwise improvement in the banking sector post globalization, because there was a scenario when there was a economic crash type of situation prior to liberalization policy of 1990s. So post liberalization, there has been a good number of regulatory mechanism, liberalized mechanism in case of banking sector, which helped them in the strengthening of the banking structure. Earlier, the amount of funds that a bank can expose to the for the risk, because what is scenario is that every industry wants to earn maximum profit, but at time there is a feasibility that there is a sector which is giving risk to the investment, and nobody is sure about what will be end of that facing that risk. So in that scenario, there was an assessment that how much risk area we can try, how much safe lending we can do. So the investment of bank was so channelized, or banks funds were so need to be so managed that they need to put some amount with the RBI as a safeguard. They need to put some amount in the safe investments, including the government assets or sort of thing. They may put some amount in the equities. They may put some amount for the loan purposes. So likewise, bonds and also secured bond or different kind of mechanisms are there. So these kind of regulations came into picture, and they are also associated with the banking license mechanism. Bank need to take license to operate, and it need to abide by those conditions that are approved through that license. No, without license, banks cannot operate, and including if we need to start a new branch as well. So for that purpose, also license is required from the competent authority in this regard. Then the concept of regulation with reference to bank was not limited to the licensing, but it ventured into the bank management also. So bank management, what may be the structure, what may be the participation in the bank management, what will be the board structure, how government will be representing in that board. All these things came into the picture through the regulation mechanism. Then there is another concept, interesting concept also. There is a necessary requirement to remain updated or submit their reports or status on regular basis to the competent authority, including the RBI. So if you try, if you wish, you can try the RBI website for various purposes, banking related information, and this information is usually on the basis of, in some parameters, it is on the daily basis, it is on some parameters, it's on weekly, monthly, quarterly, annual basis. So if you want to look for the priority sector lending done by a specific bank, that report is submitted to the RBI. and RBI on regular basis keeps on updating this information on their website as well. Then how much loan a bank is disbursed, how much funds it has received, what is their NPA. It is all together, and if NPA is there, in what sector it is there, how much amount that bank has uh, invested in the government securities, how much amount it has invested into the bonds or on a risk segment. So every information need to be reported in the form of specific formats to the RBI, and the RBI keeps on updating this to the in the public domain as well, including their internal circulation as well as the public domain. And all these things are mandatory requirement. Then there is a concept of auditing, inspection and auditing. The inspection or this auditing may be internal as well as the external as well, or independent auditing. So banks do have their independent internal audit mechanism in which there is usually what happens is on annual basis there is a officer or a group of officers. They keep on auditing the activities of that branch, and pinpoint if there is some error, and the branch respective branch need to address it if it is not functioning as per the norms specified by the government in that regard. So that is one aspect. But at the same time, there is a prevalent provision of putting of statutory auditors. They are basically they may be retired officials from the bank sectors also, and they are hired post retirement. They are supposed to do auditing as well. So that is another auditing mechanism. And there may be auditing if it is altogether required by the third party also. So these kind of mandatory requirements are there. But the final phase of this unit may be, suppose they are not at all following what is there, means they are not following the regulations. So under this, there are at least three type of penal powers that are empowered on. One is legislative for rule making, then executive and judicial. So in the judicial power, there is a power to impose penal sanctions as well. So RBI can deny the permissions which can be expected from it, or deny the enjoyment of the regulated entity. Suppose in a scenario when bank is operating but it is not following the instructions, government regulations, or RBI instructions. So and at times it requires some permissions from RBI for its routine operation, which is obvious kind of thing, which ought to be given by the RBI. But this time, because the bank is not obeying or following the directions, RBI can deny those permissions as well. It can forbid it from doing what constitutes the core of banking business, a denial of which might mean a slow death of a bank, imposing a fine on the bank and or its officers. Well, cancellation of licensing of the bank itself or its branch. As I mentioned, that bank can operate with the license from the RBI only, and also it need to get the license for its branch as well. So RBI under penal powers can cancel both, one or both. Then initiating the winding up of the banking company, then penalizing the shareholders without winding up. And we have seen that the RBI acts a umbrella to protect the investment of the investors. Well, at the same time, there is also to safeguard the banks also from the fraudulent borrowers. So RBI acts in positive manner for banking sector, if we can say so. It ensures protection of right of investors. We have seen in the recent past, and when there was some maybe some news or maybe some assumption that a specific bank, cooperative sector bank, is likely to be having huge losses, and the amount invested in that bank may be altogether lost. So RBI venture into the segment. It instructed and regulated the funds of that bank, specifically with the intention and instruction that the core intention is to safeguard the investment of the investors. Uh, and there are scenario when the borrower fraudulently take away the money of the bank, as we see in the couple of cases in recent past, where the Mr. Modi, Nirav Modi, and other Mehul Choksi and a couple of other person who took away money fraudulently from the bank, and they run away from the country. So RBI and other agency of the government went into action, and they seize their property that is altogether in India, as well as they are legally fighting case against them. So RBI or government agencies, in fact, we can say, is working towards the safeguard of investment as well as the bank also. And in other terms, in the liberal terms, we can say they are also looking forward for the avoidance of harassment to the genuine borrowers also. We can understand that enterprising is a risky affair. So if in case there is a untoward incident or unexpected incident which is affecting the banking or which is affecting the investment or return on that investment. So under those scenario, definitely investment may be lost. So to address those situation and to address the harassment of the borrower as well, genuine borrower, government may at times provide some uh, leverages to the borrower as well. They can also extend their repayment durations and waive of certain interest also. So that is altogether is also provision with the main core intention to safeguard the bank and the banking sector in or in total component, all the component, the investor as well as the borrower. Then the next unit is, that is unit number 8. It is foreign exchange management and related regulations. Well, we understand that definitely the funds are altogether required, and funds may be from the own source or from the domestic banking sector, but at the same time, the funds may also come from the foreign country, or funds may also go to the foreign country or foreign land, either directly in the form of a fund or maybe investment in that country or in this country. This concept of investment may be in the positive sense, but to ensure that it is in the positive sense only, and to safeguard the national integrity and economic stability, and to avoid any turbulence in any scenario, there is a need to regulate this foreign investment. So for that purpose, the Foreign Exchange Management Act, that is Act number 42 of 1999, has been formulated by the central government to basically to consolidate and amendment the law relating to foreign exchange with the basic objective of facilitating external trade and payments, and definitely for promoting the orderly development and maintenance of foreign exchange market, specifically in India. Basically, the FEMA, it has been evolved over the period of time. Initially, in 1939, there was a Defense of India Act, which we can say temporary, but was sort of first legislative attempt to regulate and control the foreign exchange in India. It has got an aim to settle the foreign exchange crisis in the country, and the Foreign Exchange Regulation Act, which was first enacted in 1947, further replaced by FERA in 1957. Well, which is the immediate predecessor of FEMA, that is Foreign Exchange Regulation Act of 1973, in a chronological order. And the objective of these acts are basically to regulate the foreign exchange rather than managing it. Well, it aimed to regulate the foreign exchange by preventing the outflow of Indian currency, regulating dealing in foreign exchange and securities by imposing several kinds of restrictions or on transactions involving foreign exchange and on persons dealing with foreign exchange. Well, it provides, FEMA basically provides a legal framework for the proper management and administration of the foreign exchange transactions in the country. And it came into the force in June 2000. And since then, definitely since then, it has been amended from time to time according to the changing economic policies and objective of the government. Well, there are approximately six rules framed by the central government and 23 regulations notified by the RBI under the FEMA Act. And as far as its structure is concerned, it is divided into seven chapters, uh, which are further divided into sections, and the overall skeleton is chapter 1, which is preliminary, containing section 1 and 2. Chapter 2, which is related to regulation and management of foreign exchange, contains section 3 to 9. Chapter 3 defines the authorized person, and it is defined under section 10 to 12. Then under chapter 4, there are contraventions and penalties that are defined under section 13 to 15. Then chapter 5 is adjudication and appeal, which is defined under section 16 to 35. Then under chapter 6, it is direct rate of enforcement under section 36 to 38. And under 7, chapter 7, it is got miscellaneous sections ranging from section 39 to 49. Well, it also includes rules by the Ministry of Finance, which are defined under section 46, and regulations made by RBI, which are defined under section 47 of the Act, which we can say subordinate or delegated legislations. Usually, every year, based on previous experience from the past year, based on the requirement for the upcoming year, master directions are issued by the RBI, and it is the basically foreign direct investment policies issued by Department of Promotion of Industry and Internal Trade, that is DPIIT, and notification circulars issued by RBI rules made under FEMA. There are a variety of circulars that we can say that FEMA, it is encashment of draft check instrument and payment of instrument rule 2000, then authentication of documents, current account transactions, adjudication proceeding, appeal. Then there is a concept of appellate tribunal for foreign exchange recruitment, salary and allowances and other conditions of service of chairperson members, Rule 2000. Then there are certain regulations made under FEMA, that is acquisition and transfer of immovable property outside India, Regulation 2015, borrowing and lending in rupees, Regulation 2000, borrowing or lending in foreign exchange, deposits, Regulation 2016, export and import of currency, Regulation 2015, guarantees, Regulation 2000, acquisition transfer of immovable property in India. Well, the FAM 2015 for the immovable property outside India. Well, there is a regulation for the immovable property in India as well in 2000. Well, establishment in India of branch, office, or a project office, or any other place of business, Regulation 2016. So likewise, there are a series of regulations that are updated time to time, ranging from remittance, realization or repatriation of surrender of foreign exchange, possession and retention of foreign currency, likewise. So, and the list is adding or adding also. In any act or any regulation, there are certain definitions. So the definitions like who is a person resident in India, because for FEMA purpose, there must be something that is applicable to a specific group of persons. So one is the who is a resident, or who is a person non-resident, or a NRI or a foreigner. So based on their fitment in a specific definition, the rules apply. So it applies for the, if it applies for the persons resident in India, so they can be defined as a person residing in India for more than 182 days during the course of preceding financial year, but does not include a person who has gone out of India for or who stays outside India in either case, for or on taking up employment outside India, or for carrying out outside business outside of India, or vocation outside India, or for any other purpose in such circumstances as would indicate his intention to stay outside India for an uncertain period. Well, a person who has come to or stays in India in either case, otherwise than for or on taking up employment in India, for carrying on in India a business or vocation in India, likewise. It may include an office, branch, or agency in India owned or controlled by a person resident outside India, an office, branch, or agency outside India owned or controlled by a person resident in India. So these are the categorization for a definition with reference to resident of India. Well, the regulations in this act includes the major one. The chapter 2 provides for the provisions related to the regulation and management of foreign exchange in India. Well, there can be no dealing in foreign exchange without the general or special permission of RBI. The Act also does not empower the RBI or any other person to directly handle the foreign exchange. For this, the RBI can authorize authorized persons and issue directions to such authorized person from time to time. Well, the transactions under FEMA may be two types. One is capital account transaction and another one is current account transactions. Well, the capital account transactions are they are governed by the Act and the FEMA, that is permissible capital account transactions. Such transactions which alter the assets or liabilities, including contingent liabilities outside India of persons resident in India or assets or liabilities in India of persons resident outside India, are called as capital account transactions. Then RBI has the power to regulate the foreign exchange, and it can prohibit, restrict in a manner, transfer or issue any foreign currency security by a person resident in India, transfer or issue of any security by a person resident outside India, transfer or issue of any security or foreign exchange by any branch, office, or agency in India or person. Likewise, it also deals with the borrowing also, and deposits, transfer of immovable properties, acquisition or transfer of immovable property in India other than a lease not exceeding 5 years by a person resident outside India, giving of a guarantee. In fact, not only direct dealing, also guarantee is also considered guarantee or surety in respect to any debt, obligation, or any liability incurred by a person resident in India or owed to a person resident outside India by a person resident outside India. Well, as far as the mode of acquiring property in and outside India is concerned, modes of acquiring property outside India by a person, by a resident, modes of acquiring property in India by a non-resident. So then there are classes of capital account transaction. It is altogether defined. The classes of capital account transaction of persons resident in India and persons resident outside India. Previously, we talked something about the capital account transaction, and there is a provision for the current account transactions also. So, other than capital account transactions, the transactions are considered the current account transaction, and they may include the payments due in connection with foreign trade, other current business services, and short-term banking and trade facilities in the ordinary course of business. Payments due as interest on loans and as net income from investments. Remittance for living expenses of parents, spouse, and children residing abroad, and expenses in connection with foreign travel, education, and medical care of parents, spouse, and children. So there are certain schedules like Schedule 2 transactions which are prohibited: remittance out of lottery winning, remittance of income from racing, riding, or any other hobby, remittance of purchase of lottery tickets, band, prescribed magazines, football, pools, stacks, etc. Payment of commission on exports made towards equity investment in joint venture, wholly owned subsidiary board abroad of Indian companies, likewise. Payment related to callback services of telephone, and remittance of interest income on funds held in non-resident special rupee account. Then there are Schedule 2, 3. Schedule 2 deals with the transactions which require prior approval of the central government, and the transactions which require prior approval from the RBI. Then we talk about the concept of authorized person, because RBI doesn't deal directly; it deals through authorized person, and those authorized person maybe we can consider as a authorized dealers, money changers, or offshore banking units, or maybe called as any other name. So, who are authorized on behalf of RBI to deal in foreign exchange or foreign securities. The RBI shall definitely authorize such person in writing and shall be subject to conditions laid down by RBI. And as an authorized person, an authorized person shall, in all his dealings in foreign exchange or foreign security, comply with general or special directions or orders of RBI. Without the prior permission of the RBI, bank and authorized person shall not engage in any transaction involve any foreign exchange or foreign security which is not in conformity with the terms of his authorization. Then, in case of contravention and penalties, if any person contravenes with the provisions of the Act, rules, regulation, and notification, direction, or other thereunder, or contravene any condition subject to which an authorization is issued by the RBI, there are certain penalties provided by the RBI. Then they may be penal or they may be imprisonment as well, seizure of cancellation of license, seizure of property, all these things are there. But at the same time, there is a provision for the appeal also. So the acts provide the provision for appeal in three stages. Appeal before the special director, that is appeals against the order of the adjudicating officer. Then appeal before the appellate tribunal against the order of the special director. And finally, appeal before the high court, that is definitely against the order of special director. Then there were conditions to the level of appeal, and the time lapse between appeal can be run before a specific time. Then there is a body that is Directorate of Enforcement. This Director of Enforcement is establishment of the act by the central government, and the central government appoints the director and other officers who are together called as officers of enforcement, and they have power of search and seizure. And there are special provisions relating to assets held outside India in contravention to Section 4. Then compounding of offences under FEMA is possible. Well, in terms of rules, the RBI is empowered to compound contraventions related to Section 7, 8, and 9, and the third schedule of the FEMA rules. RBI was empowered to compound all the contraventions of FEMA 1990 except Section 3A of the Act 16 Act. The contraventions that can be compounded by the RBI, where some involved in such contravention is 10 lakhs rupees or below by the AGM of RBI, more than rupees 10 lakh but less than 24 lakhs for the less than 40 lakhs by the DGM, then 40 lakhs but less than 100 lakh means 1 crore by the GM of the RBI, and rupees 1 crore or more by the CGM. Well, no contravention shall be compounded unless the amount involved in such a contravention is quantifiable. Well, next is the unit number 9. It is regarding insolvency and bankruptcy condition. Well, there may be situation when the industry is failed and or an entrepreneur is failed and it is not in position to return or pay back the money. So there is a need of a mechanism through which its assets can be dissolved or insolved, and the assets can be converted into the funds, and shares or investment can be returned back as far as possible. So it is covered under this unit. As per the United Nations Commissions on International Trade Law, that is UNICITRAL, the legislative guide on insolvency law, it defines insolvency as a insolvency is when a debtor is generally unable to pay its debts, and as they mature or when its liabilities exceeds the value of its assets. So the interesting aspect is the liabilities exceeds the value of assets. So definitely the liabilities are at risk. So to negate the upcoming ultimate loss of all the liabilities or zeroing down of the neutrality of the assets, the insolvency process is initiated. In terms of UK Insolvency Act, 1986, there is a renowned author, Sir Roy Wood. He observed that a company is insolvent when it is unable to pay its debts. And the concept is simple enough, but as we shall see, there's more than one test of inability to pay debts, and in marginal cases, it may be far from easy to determine whether the test is satisfied as at the relevant time, because there may be a situation when some amount is likely to be not returned back, when at the same time it returned back, so situation is flexible, so marginal cases it's not easy to assess. So surprisingly, unlike the international laws, the code does not define insolvency in explicit terms. However, the default by the corporate debtor has been marked as a trigger for initiating the insolvency proceedings. Well, the Bankruptcy Law Reform Committee report, BLRC report, explains it in following terms, like it may be a financial failure or it may be a business failure. A persistent mismatch between the payments by the enterprise and receivables into the enterprise, even though business model is generating revenues. Well, business failure is a breakdown in the business model of the enterprise, and it is unable to generate sufficient revenues to meet payments. So there are two conditions, two terms important. Then one is financial failure, another one is business failure. In financial failure, definitely there is a persistent mismatch, even though it's generating revenues. Well, the corporate insolvency regulation framework in India, which was prior to 2016, it has a patchwork of insolvency codes, tribunals applying to different classes of stakeholders or processes, which resulted in parallel proceedings, conflicts between different statutes, and uncertainty for creditors over their recovery. So here, the main stakeholder is creditor. So to safeguard the creditor or investor, so they need to do something to safeguard their investment. The conflicts and multiple proceedings that have arisen from the multi-layered insolvency law enforcement framework pointed towards a strong need for a unified bankruptcy code. Well, that could be applicable to all aspects of a company in distress and for all stakeholders. The complex web of laws, which till recent past governed corporate bankruptcy and insolvency, included Companies Act, Companies Act of it is Companies Act, the recent one, 2013. It is defined under Chapter 19 and 20. Then Companies Act of 1956, which was preceding to this 2013 one. Then there is a Sikh Industrial Companies Act, SICA of 1985. Then there is a Recovery of Debt Due to Bank and Financial Institutions Act 1993, that is called as RDDBFIA. Then there is a Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. It is called as SURFACI Act. Well, it is an interesting one as well. This act enables secured creditors to take possession of collateral without requiring the involvement of a court or tribunal. Well, this law provides for actions by secured creditors to take precedence over a reference to a debtor to BIFR. The DRD is the forum for appeal against such recoveries. Well, issues relating to various legislation dealing with corporate insolvency and restructuring, SICA. Under the SICA, industrial companies whose net worth has eroded by 100% are identified as being in distress and are referenced to BIFR. Thereafter, the BIFR must investigate the potential viability of the industrial company and then either recommend its rehabilitation scheme or winding up before the High Court. Well, major issues with the legislation are delay. Under SICA provisions, 5 to 7 years are required for reviving a company out of which around 3 to 4 years are required just to decide whether a particular company needs rehabilitation or liquidation. Delays further contribute to other issues such as debtors use the delay to defer payments to the creditors because of the moratorium that it placed under the creditor enforcement corporate as being siphoned off during the loan drawn process. Managers coercing creditors into extending further finance or giving concessions in existing debts. Well, it has been observed that Sika is capable of achieving a swift liquidation only where creditors reject possibility of revival only. Earlier, they can take the time on sort of thing. Improper identification of companies that can be restructured. It has been repeatedly stated that the BIFR has failed to satisfactorily identify companies capable of restructuring or have sanctioned schemes which have severely hampered the creditor's interest. Then SICA does not assess the creditor's insolvency and bankruptcy. In many cases where the creditors seek liquidation, the cases have been sent back to BIFR to conduct inquiry into rehabilitation. Well, then SAFASI Act, RDD, BFI also have their own plus and minus. Then in Unified Insolvency and Bankruptcy Law, that is the Insolvency and Bankruptcy Code 2016, it has got a host of legislation and forum combined with potentially conflicting jurisdictional issues, which resulted into systemic delays and complexity in the insolvency and bankruptcy process in India. Additionally, all these legislations have been identified as being inadequate in by themselves as well. So this code need to be enacted, and it was enacted in 2016. The salient features are it follows clear, coherent, and speedy process for early identification of financial distress and resolution of companies and limited liabilities entitled if the underlying business is found to be viable. Two distinct processes for resolution of individuals, namely fresh start or insolvency resolution. Well, there are four pillars of institutional infrastructure under IBC of 2016. One is insolvency professionals and insolvency professional agencies. Then information utilities, adjudication, and Insolvency and Bankruptcy Board of India, IBBI. The Insolvency and Bankruptcy Board of India, IBBI, the Insolvency Professional Agency, insolvent professionals, and information utilities are altogether very important. Then constitution of board and selection of members. The board shall consist of following members to be appointed by central government, who shall appoint them other than the ex officio members after obtaining a recommendation of a selection committee. The board consists of chairperson, three ex officio members from amongst the officers of the central government, not below the rank of joint secretary or equivalent, one each to represent the Ministry of Finance, Ministry of Corporate Affairs, and Ministry of Law, one ex officio member to be nominated by the Reserve Bank of India, and five other members to be nominated by the central government, of whom at least three shall be whole-time members. The tenure of the office bearers is given in section 189, subsection 4 of the IBC code, and the term of office of all the members except ex officio members shall be for a period of 5 years or until they attain the age of 65, whichever is earlier. They are eligible for reappointments as well. Well, the objective of board is to ensure to utilize all legislative, executive, and quasi-judicial functions so as to achieve a well-functioning bankruptcy process in India. Well, this also include features of high recovery rates in NPV sense, low delays from start to end, sound coverage of the widest possible class of claims, bank loans, corporate bonds, etc. A perception in the minds of persons in the economy that India has a swift and competent bankruptcy process. Then the corporate insolvency resolution process involved trigger point for initiation, ascertaining existence of debt default by NCLT, date of commencement, declaration of moratorium and public announcement, moratorium, exclusion from moratorium, conduct of corporate resolution process by resolution professionals, resolution plan, approval of resolution plan by creditors, approval of plan by NCLTT, rejection of resolution plan, punishment of for contravention of resolution plan, appeal before National Company Law Tribunal, Appellate Tribunal, The liquidation process under Act include commencement, public announcement, and other steps also. As far as the individual insolvency is concerned, the insolvency code in part third provides for insolvency resolution and bankruptcy for individuals and partnership firms also. The significant features include there are two distinct processes in case of insolvency: automatic start and insolvency resolution. The code applies in cost with in all cases where the minimum default amount is you can see rupees 1,000 and above. The insolvency resolution process consists of preparation of a repayment plan by the debtor for approval of creditors. If approved, the DRT passes an order by binding the debtor and creditor for the repayment plan. If the plan is rejected or fails, the debtor or creditors may apply for bankruptcy order. The creditor and debtor are required to agree on repayment plan for restructuring debts and affairs of the debtor under the supervision of the IP. Such repayment plan requires approval of 75% of the financial creditors. The code prescribes a timeline of 180 days for the insolvency resolution process. In case of fresh start process, under the automatic fresh start processes, eligible debtors may be on the basis of gross income can apply for DRT for discharge from certain debts not exceeding a specified threshold, allowing them to start afresh. Under this, an application may be made by eligible debtors for any debt other than secured debts, which has been availed of 3 months prior to the date of application, excluded debt. Well, eligibility for a fresh start process application under the code are: applicant should not own a dwelling unit and has a gross annual income less than not less than of less than to rupees 60,000, with assets value not exceeding rupees 20,000, and aggregate value of the qualifying debt of such individual or partnership firm should not exceed rupees 35,000. In addition, the applicant should not be an undischarged insolvent and there be no other previous fresh start process application submitted by him. Well, as far as the discharge order and its effects are concerned, the bankruptcy trustee should apply to the adjudicating authority for a discharge order either on the expiry of 1 year from the bankruptcy commencement date or within 7 days of the approval of the committee of creditors of the completion of administration of the estate of the bankrupt. The discharge order releases the bankrupt from all bankruptcy debt. Well, in case, however, a discharge order will not be granted if the discharge affects the functions of the bankruptcy trustee or affects the operation of the provisions of the chapter 4, 5, or part 3rd, or releases the bankrupt from any debt incurred by means of fraud or breach of trust to which he was a party, or discharges the bankrupt from any excluded debt. Then there are certain disqualification provisions also. Uh, yeah, he is disqualified for appointment or acting as a trustee or representative in respect of any trust, estate, or settlement, appointment or acting as a public servant, election to any public office, election as a member of any local authority. Then there is a concept of cross-border insolvency also. It is defined under section 234 and 235 of the code. Then there are certain legal cases with reference to IBC. You can explore them. They are appearing on time to time. So let's move to the next unit, that is intellectual property rights. Uh, it is in fact another interesting unit, and it is altogether the basic or essence for any enterprise to start to capital on the inter IP. And as far as the definition is concerned, definitely there is no universally accepted definition with reference to IP. Well, and to be very honest, there is no possibility of having universal definition as well, which comprehensively cover all the subject matter that are currently considered as intellectual property. The global agency that deals with the information and the regulation and management also is the World Intellectual Property Organization, headquartered in Geneva, which attempted to provide relatively a comprehensive definition as well. Well, their definition is intellectual property refers to creation of a mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. As far as the types of IP are concerned, as I mentioned, that it is IP law is not a homogeneous body of law, rather a collection of distinct but related legal doctrines covering diverse subject matters. It may contain patent, copyright, trademark, geographical indicators, industrial design, plant quality protection, production of layout design of integrated circuits, trade secrets also. As far as the patents are concerned, they are on the novelty, inventive step, and industrial application. If I talk about copyright, they are for literary, dramatic, musical, or artistic work other than a photograph published within a lifetime of the author, continue until 60 years from the beginning of the calendar year next following the year in which the author dies, whereas in case of photographs, until 60 years from the photograph is published. So, is in the case of copyright for the photograph published matter, the life cycle or the protected time is the 60 years. 60 years. In case of photograph, it is from the date of it's published, and for the other work, uh, after the death of the person, 60 years after the death of the person. You can see a very interesting example of this thing. Suppose a family, suppose a father of a kid produces some literary material. So, after the death of the owner, the kids enjoy the copyright, or the family members of that original creator enjoys the copyright for like 60 years. But the smart kids, they can do the smart thing. They can reuse the same thing because they have the copyright, and reuse it within that 60 years. They create something new. Maybe they create a story, maybe they create a picture or something like that. So they further extended the cycle for the next phase also. The copyright is again protected for extended period of time. So these are the mechanism that persons do to keep their IP for a long time. Then the trademarks, they are represented graphically, and which is capable of distinguishing the goods or services of one person from those of others, and may include shapes of goods, their packaging, and combination of colors. Well, geographical indicators is indications specifically, maybe we by our inclination preference like to have some product from a specific place. So if we like to have something, they have some economic value, they have the product from a specific area, have some specific taste. So to address the, for example, if I take about the sherry, so it is preferred from the specific region from the Uttar Pradesh, that is Maliabad. So they are originated from those places. So if I talk about the sherry, so they are ideally GI tag from the Maliabad. So ideally, if it is IP protected, nobody from other place can claim it as the sherry other than the or GI tag that one. So see, so the sherry of Maliabad, if it has got a GI tag, is of a better can claim better one. Nobody else can claim that one. Like mangoes from Maharashtra, Alfonso mangoes. So they have some similar tag. Then there is a specific variety of mango that is coming from Uttar Pradesh, that is called as Ratol. So the mangoes coming from the Ratol area has got some specific type of taste, fragrance, or preference. So if they are GI tagged accordingly, they are benefited in economic terms. Nobody else can claim that benefit. Like Rasgulla fight between Odisha and West Bengal. So likewise, there are a good number of examples with reference to GI tagging also. Then industrial designs are concerned. So it contains the features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in 2D or 3D or in both forms, by any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which in finished article appeals to and are judged solely by the eye. Then there are plant variety protection. So the Protection of Plant Varieties and Farmers' Right Act 2001, that is called as PPVFR Act. It protects the right of the farmers' variety or the plant varieties, and including the farmer rights as well. This is important in terms when a lot of players are there in the introduction of new plant varieties, and the farmers need to pay for them. So the farmers have their own right as well. So that is altogether covered under IP in this specific type of act. Then production of layout design integrated circuits also coming under the IP acts or IP laws. Then the final one is the trade secrets. So trade secret, if we talk about trade secrets, one of the leading example is the example of Coca-Cola. So in this example, we understand that if the method is known, anyone can create or so. So the company or enterprise don't want to patent it because it knows that after a reasonable time of year, like 20 year or so, if it is not extending its license, it will be exhausted. So it believe if it keeps that tradition within its family or that knowledge within a specific person, it can keep it longer rather than registering it. So these kind of practices are covered under the trade practice secrets. So if otherwise, if we see the plethora of IP laws, anyone knows inventory process or novelty in any process, and it want to register it for its protection. So it can be done under the patents also. But what is happening is there is a life slot for any IP protection. As I mentioned, in case of copyright, it is for 60 years. Copyright for literary and copyright of photograph is 60 accordingly. Well, similarly for patents also, there is a deadline or a lifetime. But interestingly, this concept of trade secret is altogether very interesting. If it is kept secret, nobody will know, and it will be lasting for a longer time. So as far as known to the public, in case of Coca-Cola, there are two different persons. They have their own set of formulas or combination of information with them, and they take that combination, and when that combination is combined together in a specific pattern, only then that flavor is achieved, and nobody is they are not disclosing that thing to anything. So this is coming under the trade secret. Why these IPs are very important, specifically they are important in every sector, including majority in the pharma sector. Pharma sector, there is a huge amount of investment in the form of searching for drugs or medicines. So that the process of manufacturing is not costly. The process of selecting, designing, identifying, confirming its property is time taking and expensive. So any industry that is putting up so much investment in all their processes need to have the financial benefit out of it. So they need to protect their right, their IP, and they do it in a very genuine manner also. But after the expiry of that right, the license is open. During the lifetime of that IP protected phase, anybody cannot use that process or that product or cannot produce the same without taking license, without taking permission. But after the expiry of license, anyone can take. So a company wish to take the advantage of its R&D by protecting its IP, and this is the foundation of protection of IP in any sense. So I hope if we go for more and more regulated manner in the IPs, definitely it's going to be beneficial for the industry and enterprises. So in coming section, in coming we will be exploring another interesting aspect, that is the data protection and the privacy. So with this, I wish to conclude today's session. Namaskar.